that evidential burden. Money do your head in. Mr. Police Simon, you are the hunter of I and my ganja. By the power of Rasta, I need to run faster. I do you no harm, stop twisting my arm.
Hello folks, it's Neil here, coming to you live from the criminal court in downtown Babylon. Today we are looking at a fundamentally important concept in the law of evidence, namely the burden of proof. When people hear the term burden of proof, they often think of courtroom dramas where lawyers shout, "You can't prove that." While this image isn't entirely wrong, the concept of the burden of proof in Irish law is more structured, more detailed, and far more important than most people realize. In Ireland, the burden of proof is one of the core safeguards of fairness. It determines who has to prove what and how convincing that proof must be. These two ideas, who carries the burden and how high the standard is, shape every criminal trial, civil lawsuit, tribunal, and many administrative decisions. In this video, I do my best to explain the burden of proof in simple language, covering criminal law, civil law, special cases, and common misconceptions.
What is the burden of proof? At its simplest, the burden of proof is a rule about responsibility. If you make a claim, you usually have to back it up. This leads us to a very old saying, "He who alleges must prove." The Latin phrase is "e incumbit probatio qui dicit, non qui negat," which means the burden of proof lies on him who affirms, not on him who denies. Irish law formalizes this into two related ideas. First, the legal or persuasive burden. This is the obligation to convince the decision-maker, usually a judge or jury, that your side is correct at the end of the trial. If you carry the legal burden and you fail to meet it, you lose. In many jurisdictions, this is known as the onus. Second, the evidential burden. In a way, this is a lighter burden. It's the duty to raise an issue with enough evidence that the court must consider it and/or your opponent will need to rebut it. The evidential burden gets a topic on the table, but it doesn't necessarily decide the case. Think of it like this. The evidential burden is saying, here's enough evidence to make this a real issue as it calls for an answer. The legal burden is saying, here's enough evidence to win on this issue. As a general rule, the legal burden remains with the party to whom it first attaches at the beginning of the trial. It is usually more difficult to discharge. The presumption of innocence says that a defendant is innocent until proven guilty. Irish criminal law starts with one unshakable rule. The prosecution must prove the accused person's guilt. This is part of the presumption of innocence protected by the Irish Constitution and Article 6 of the European Convention on Human Rights. In practice, what this means is that the prosecution must prove every element of the crime with which the defendant is charged, and they must prove each of those elements beyond a reasonable doubt. To convict someone, the prosecution must reach a very high level of certainty. They don't need to prove guilt beyond any doubt. Almost nothing in life is that certain, but they must remove all reasonable doubts. A reasonable doubt means a real hesitation based on logic or evidence, not a fanciful or far-fetched possibility. If such a doubt exists, the defendant must be acquitted. As a general rule, the defendant in a criminal trial doesn't have to prove anything. The defense can sit silent, call no witnesses, and make no submissions, and the legal burden still stays with the prosecution. However, if evidence is introduced by the prosecution that requires an answer or an explanation, the defendant would be well advised to respond to that. by cross-examining the witness who gave that evidence and putting the defendant's different version to the witness, or by leading contradictory evidence when the defense makes its case. One of the exceptions to this rule is the reverse burden created by statute. Some laws say that once the prosecution proves certain basic facts, the accused must then prove something else, for example, proving a lawful excuse, showing they had no knowledge of something, or establishing a particular defense. These are controversial because they cut against the presumption of innocence. Courts examine them closely and usually interpret them so that the defendant only has the evidential burden to discharge and not the full legal burden. Apart from the statutory reverse burdens, there are also a number of common law offences that call on the defendant to prove something before the defence can be activated. Even if the prosecution keeps the overall burden of proof, the accused may have to meet an evidential burden for defences like self-defence, duress, insanity, and provocation in older case law. Once the defendant supplies some probable evidence for the defence in furtherance of its plea of self-defence, for example, the burden shifts back to the prosecution to disprove it beyond reasonable doubt. An Old English decision illustrates this idea nicely. Woolmington v. DPP, 1935, established the golden thread of English criminal law. The prosecution must prove the defendant's guilt beyond reasonable doubt. Reggie Woolmington, accused of murdering his estranged wife, claimed the shooting was accidental while attempting to persuade her to return to him. The trial judge, on the basis that the cause of death was not in issue, Reggie admitted to killing her and was therefore taken as proven by the prosecution, wrongly shifted the burden of proof onto Reggie to prove the shooting was an accident. The House of Lords overturned the conviction, ruling that, on the facts, the burden of proof always remained with the Crown. Civil law is different. These cases involve disputes between private parties, neighbours, businesses, employers and employees, family members, and so on. Here, the starting point is that the person making the claim usually bears the burden of proof. If Mary sues John claiming he breached a contract, Mary must prove her claim. If John raises a defence, say that Mary actually broke the contract first, John must provide evidence for that defence. So this is more of a shifting burden, but again, it must be argued that this is an evidential burden. The plaintiff must still have proven their case by the end of the trial, and therefore the legal burden has remained with them. Civil cases use a lower standard of proof than that found in criminal trials. Whose version of events is more probable? In other words, more likely in the ordinary course of events. A lot of people say 51% versus 49% is enough, but I would advise against that sort of thinking. This would suggest it is a pure numbers game, and that could not be further from the truth. As you have seen before, it is the quality of the evidence, not the quantity, that matters. The clue is in the name, balance of probabilities. Whilst a balance does suggest simply weighing which is the heaviest, and therefore the winner, remember, it is a balance of the probable evidence only. So one party might have a huge load of evidence and an army of witnesses, but if the evidence does not prove much, and the witnesses are dodgy, numbers don't matter because the amount of probable evidence is very little. To use a silly example, if the driver and 4 passengers testify that the car swerved into oncoming traffic because the driver had to swerve to avoid injuring a leprechaun that was running across the road. But on the other hand, a single independent witness testifies for the plaintiff that she saw the 5 people stagger out of a pub and the car then raced out of the car park at a phenomenal speed before going straight into an oncoming vehicle. Guess who would lose? Judges sometimes express it as deciding what probably happened, again using current knowledge and common sense. As previously mentioned, civil cases often involve shifting burdens. Once the claimant proves the basics, the defendant may have to explain their conduct or produce records only they possess. Common examples include negligence. The plaintiff must show a duty, breach, and damage, but once negligence is suggested, the defendant might need to show they took proper care. Employment law. An employee alleging discrimination must raise facts suggesting discrimination. Then the employer must prove it acted lawfully. Family law. In certain applications, such as maintenance or access, the burden may be shared or fluctuate as circumstances change. Irish law uses additional standards outside criminal and civil courts. Tribunals and inquiries. Tribunals of inquiry don't determine guilt or innocence, but their findings can seriously affect reputations. They generally use the civil standard, but apply caution when making grave findings. Administrative decisions. Licensing bodies, regulators, and immigration decisions often use the balance of probabilities, unless legislation specifies otherwise. Constitutional litigation. When a law restricts a constitutional right, the state must usually justify that restriction. This includes showing a legitimate aim, necessity, proportionality. Here the burden is not about facts, but about justification, especially in proportionality analysis. There are many common misunderstandings about evidence and the burden of proof. Here are a few. Myth 1. If I'm accused of something, I must prove my innocence. No, not in criminal law. The prosecution must prove guilt. You never need to prove innocence. People get confused because sometimes the state leads evidence that demands a reply or explanation. This can feel like you are proving your innocence, but actually the legal burden remains on the prosecution throughout to prove your guilt. Myth 2. Reasonable doubt means all doubt. Again, no, jurors don't need to be 100% sure, just firmly convinced without reasonable hesitation. Myth 3. Civil cases are always easier than criminal cases. The standard of proof is lower, yes, but civil cases often involve complex evidence, technical disputes, and shifting burdens. Myth 4. If both sides have equal evidence, the judge decides who they like more. No, if the evidence is evenly balanced, the party with the legal burden loses. That's the whole point of having it. There are no goalless draws in a courtroom. The burden of proof protects fairness. It prevents people from being convicted on suspicion, rumour, or weak evidence. It forces the state to justify its actions. In civil law, it ensures that people who make claims must support them with evidence, while still allowing flexibility where one party controls most of the information. It also shapes how lawyers build their cases, what to prove, what to challenge, what defences to raise, what evidence is essential. A misunderstanding about burden or standard can determine the entire outcome of a case. The burden of proof in Ireland is not just a technical rule, it is a cornerstone of justice. In criminal cases, it protects liberty. In civil cases, it ensures fairness between private parties. Across the legal system, it guides judges, juries, and practitioners in deciding who must prove what and how convincing they must be. Even though the concept sounds simple, prove your claim, its consequences are profound. Understanding it helps anyone better grasp how Irish courts reach decisions and why certain protections exist. If nothing else, remember this. In Ireland, the person who makes the serious accusation must carry the serious burden. And that is as it should be. He who alleges must prove.
I hope this video has made the concept of the burden of proof a little easier to understand. Remember, if you start with the premise, he who alleges must prove, things should fall into place after that. I'm Neil, and this has been The Law is My Oyster.
The burden of proof, it's like just levy. If you don't shift it,